Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about appealing the admission of a will in Illinois Probate. So a probate case, when a will is involved, is usually opened by the executor petitioning to admit the will to probate. And then parties who disagree with the will being admitted to probate and treat it as the valid will of the person who deceased, known as the decedent, have the opportunity to file a will contest within 6 months of the date that the will was admitted to probate. They can also request a formal proof of will hearing, and we have articles and videos about what a will contest is and what a formal proof of will hearing is. This is different from an appeal, and we'll explain why in a minute. A will can be contested based on any number of grounds for it being invalid. It might not have been properly executed. The person who executed it might not have been of sound mind. The witnesses might not have executed it contemporaneously with the creator of the will. There might have been duress or fraud. So there's a lot of grounds for a will contest and a lot of grounds for a will not being valid. So a will contest is a way within the actual probate case to challenge the validity of the will. An appeal is requesting the appeals court, which is a court above the probate court, to overturn the order of the probate court. So generally, an order admitting a will to probate is not appealable, and here's why. The only things that are generally appealable are final orders, so final judgments that dispose of all of the items in a case. For this reason, the general rule is that orders admitting a will to probate are not appealable because it's not considered a final order. There's still a lot to go on in the probate case after that happens. However, Supreme Court Rule 304B provides for the immediate appeal of any judgment that finally determines the right or status of any party. So for some parties whose rights and statuses are finally determined by the order admitting the will being entered, like heirs who are written out of the will, people who would otherwise inherit if the will wasn't valid, or legatees of previous wills, meaning people who were beneficiaries of previous wills who, if this will is valid, will not inherit anything. Those people can appeal the order admitting the will to probate because, according to Rule 304B, the judgment admitting the will finally determines the right to participate in the case. So you can appeal that to the appellate court. Now, again, this is different from a will contest. A will contest is filed with the probate court, and it's telling the judge that you have a problem with the validity of the will. So here's an interesting distinction. Even though heirs or legatees that are essentially written out of the will in question can appeal the order admitting the will, the appeal is considered moot and thus not allowed if a will contest is also filed. So there's basically two ways you can go about doing it. You don't really want to appeal the order admitting the will. What you want to do is file a will contest, and if you lose the will contest, if you're challenging a will, then you can appeal the final order on the will contest, and that can be appealed to the appellate court just like any other appeal. So to kind of sum this up, when a will is admitted to probate, really the proper thing to do is file a will contest, challenge the will in the probate court. If you lose the will contest, then you can appeal to the higher court on the order that granted that dismissed your will contest. The reason you want to do that is that gives you two bites at the apple. You get the first chance at the will contest with the probate court and the circuit court, and then you get to appeal that if you lose that will contest. Although technically, if you are one of the people that was written out of the will, like an heir or a legatee of a previous will, you technically can appeal the admission of the will to probate as it's admitted to probate, as long as you don't also file a will contest. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.